Yes, Mr. Tavoy.
Thank you, Judge. I was just pausing because my learned friend said there may be a further authority they may want to rely on, and I'm not sure whether to. Perhaps I think you would suggest they may be relied on in reply, in which case perhaps I can.
Well, if there's any new point that we need to hear you back on, well, then you'll get you'll get the opportunity to respond.
I think that's the only way I can deal with it.
Yes.
Sorry, I actually still opening my bundles. So, I'm going to start with a sort of broad submission about the nature. I think it applies to all three of the grounds, as I'll call them. The sort of submissions unpacking one of the grounds. And it is about the nature of reason making or fact finding in the context of a task that concerns finding as to past persecution, which is, if you like, the first grounds, second grounds concern, and as to finding as to future risk, which is the first grounds concern. And it is this, that when one looks at the authorities, and it would perhaps inevitably be the case, you do get types of asylum protection cases where the issue is, will there be repetition of the same, because there has been a finding of a not particularly, shall we say, serious treatment in the past, and the question is, will it repeat itself? And we see that, and this falls into that class of case, and that class of case is present in the form also of authorities in your bundles. The first being Kaya, which is the one actually cited by the...
None of that is particularly surprising, given the UN handbook, which says expressly what has happened, I won't get the words right, but what has happened in the past.
Yes.
It may be
yes.
a reliable indicator of what is going to happen in the future.
Absolutely. So it comes from that, but why it's a particular class and not just all protection cases as per the handbook is that you also get cases like, say, Demikaya, where it's not so much a failure to make sufficient findings on future persecution, but rather the failure to refer to the past persecution. So in Demikaya, it wasn't a question of it being a sort of low-level persecution, but rather there was a failure to consider accounts of de facto torture and so on. So the issue is, why was there not consideration of whether that should repeat itself? Was there, for instance, a finding of that the conditions in the country changed? And there was no finding on that front. So if I could just show you Kaya. So paragraph 17 is the key one. It's on page 82. The authorities. So the adjudicator's conclusion in substance was simply this, that there was a risk that if this appellant were returned to Zimbabwe in certain circumstances, he might suffer the sort of ill treatment to which he had been exposed in the past, but there's nothing in which the adjudicator could have found, nor did he find, that this appellant was at risk of anything more serious than that.
What paragraph are you reading from?
That's paragraph 17, my lady.
17. Okay.
And as to the sort of issue as to sort of what was going to repeat and not get worse or become worse, we see paragraph 10, which is on page 80.
Right, so you're here in Nahangu.
No, this is Kaya, my lord. Nahangu is the other instance of this class that I say.
Well,
this
the
case.
reference that you've just given seemed to me to be to Hengu, but
Apologies.
Well, it is. You did read from paragraph 17 of the authority at tab 6 on page 82.
Apologies.
But
Lady,
we
I'm
have it.
confusing myself. Certainly,
That's
That's
is
Nahengu.
Nahengu.
Nengu. Sorry, Nengu is certainly then an instance of this this sort of case.
You wanted us to look at paragraph 10 of Nengu?
But for the facts in Nengu, it's paragraph 4. I hope that's not another confusion.
Yeah, no, it's not.
This describes what happened in the past. It talks about the past assault and the nature of it.
Well, the assault leading to the police taking no action.
Yes. Yes.
Yeah.
And then at paragraph 10, the adjudicator's finding in relation to that. Finding that it didn't meet the relevant threshold. And then it went to the IAT, who found that that was erroneous. And then 17 is the Court of Appeals conclusion, Lord Justice Kennedy. And so I'm referring to this because it's indication of sort of class of case that we are in. And why it's relevant is that it's relevant to the standards, effectively, of reasoning in that context. So in the context of a case like Dimikaya, the standard of reasoning and the error found was a requirement, there being uncontested evidence, effectively, of torture, is to find why that should not recur. And there was a failure to do that. In the Nengu context, and in our own, the reasons required are take into account the question that the issue is of repetition, and if the finding is, and the case put is that what happened to me before will repeat itself, and the finding is that there's acceptance of those facts, as in this case, then that goes a long way to establishing what will happen in the future. And to say how that then applies to the submissions here. So the first ground is about findings on future risk. And if I could take you to the first tier's judgment. So it's done in two parts, as you'll recall. There's, under the heading conclusions, it's the findings on past treatment. 35 is risk on return. And what the judge says is that, having accepted under, in the paragraphs 28 onwards section, that what was said to have happened did happen, the judge then says, I have considered whether there is a risk of repetition, and essentially finds that there might be, and it's only might because it's future risk, so it's evaluative. And so, having accepted all those facts, it's quite difficult to see what is missing. The tribunal is not required to make findings on what's not alleged to have been part of the factual experience in the history, retrospectively, in the account of the historic event. And then if their finding on future risk is about repetition, then that effectively copies across to the future not on a, albeit in a risk, via a risk lens rather than a historic fact finding lens, the same, and in the process populates, if you like, the factual findings as to the future. And that is effectively the short answer in a case like this class of case, as to the first part of that three-stage test that we see from Stanley Burton in the, or Justice Stanley Burton quoted in the MI case, which is to say there are these three stages. One is factual findings, two is what's the legal threshold, and three, what the evaluation, applying the one to the other. The fact stage is satisfied, as I say, by acceptance of the alleged facts. See, in this case, that is at 1, the claim, which is quoted at 21, and then 32, accepting that claim. The legal threshold, and there's, for good measure, because it is a judgment, in 36, you see some more, if you like, summary of the same.
What did the judge mean when he said in paragraph 31 that, as the presenting officer noted, the appellant's claim chimes with the information provided in the CPIN?
I can only infer, my lord, but perhaps arrested and subsequently released at 322, or and that not being sufficiently serious by its nature, repetition to amount to persecution.
Sorry, where were you?
He quotes the CPIN at 25.
Sorry, yes, paragraph 325, where he quotes that source.
Yes. Or even the quote below that, 327. Or
So
even
your
321.
aphorism was, it's not exactly your word, but it's past harm populates future risk.
Yes. Yes, in the scenario in which...
I mean, there will be cases where no doubt there will be additional information,
yes,
which will then tilt it in one direction or another. But as a working tool for an assessor of risk, you identify what territory you're in for past harm, accepted on.
yes. It's the starting point for my lord's point about the handbook. And the rules, in fact, I think, demand that same principle. And those complications, those other cases might be, it's got worse because of all my surplace activity, say, since I got here, or things have got worse in the country.
Yes, or they've been issuing warrants against me
Yes.
continuously since I left.
Yeah, or I've taken up a religion that the authorities don't like, or something like that may mean that between the past there's a sort of prismatic effect where it's not just a mirror effect, but rather a prismatic complication, if you like. But in the scenario of Nengu and our own, and I thought Kaya, but we have to abandon that because I've got the note wrong, but that is sufficient for this question of reasons and sufficient findings, if sufficient findings is the right way to look at future.
Mr. Binsky says, I perfectly understand the submission that, well, one can't say that he's not going to, on return to Vietnam, simply be locked up without limit of time. That's one of the things that can happen to people, apparently, looking at the report. And so what's the analysis of that sort of submission?
Our response to that is it doesn't seem to have ever been the case. There's a whole, you were taken at one point to the criminal code in Vietnam, for instance, and how certain mischiefs might befall you there. But if it's not your case, if it's not in issue, and your case is a package of facts, namely what's happened to you, and you say this may happen again, then that's all that is in issue. It's not on the tribunal to say, the CPIN says that another peril that might befall you in a given case is X, Y, Z, and I better tick those off.
It would have been open. I'm not particularly speaking about this unfortunate appellant, but to somebody in that position, to bring forward additional information, which says, well, actually, although it might be surprising to you, actually there is credible information which might pass the low threshold, that I really am at risk of something entirely
New.
other,
Yes. Yes.
something on a different level of seriousness
Yes.
happening to me in the future that has happened to me in the past, and of course one could never exclude that.
Yes.
But your answer to that is effectively that in terms of the definition of the issues, by focusing on what it is that has been alleged happened in the past, and looking at what the individual's case is before the fact-finding tribunal.
Yes.
It wasn't ever this appellant's case that he was at risk of more than he'd experienced before.
Yes, exactly, milady. And that goes to the heavily stressed point this morning about the charge.
Yeah.
Now, it's not our understanding, not having appeared below, that that's ever been this big front and centre point about disregard almost of it per se amounting to error of law. But what would its relevance be as a persecution question? Presumably, charge as prelude to prosecution. And prosecution can, in convention terms, where discriminatory, be amount to persecution. But that's never been the case either. So the fact of those, that's nor indefinite detention, nor...
No, on the other hand, we were taken to, can't remember exactly where it was, but either a regulation or a case which suggested that where a person had established that they were at risk of particular treatment, which even might be persecutory, then it is for the expelling state to show that it wouldn't eventuate in their case.
Yes.
So it would perhaps be, putting it here, it would be for the expelling state to show that although he had been charged, nothing was going to happen with that charge.
Yes.
If he went back.
I think that issue, I think you were referring to, I think it may have even been in Micaiah, where it talks about burden of proof.
Yeah.
So where an individual is detected...
It's JK in Sweden. It's referring to Article 4.4 of the Qualification Directive. It's the Grand Chamber's judgment in JK in Sweden.
Anyway, the point is that
it is.
once you've established that you are at peril of something, or might be at peril of it, then the burden shifts to the expelling state to show that that's not going to apply in your case for one reason or another.
Well, what I was going to say, milady, and I'll have to check JK, I mean, it's a very long judgment, so I may need some assistance as to the paragraph, but in scenarios where an individual, I think it may even be, one of my friend's two Article 3 cases, where I think, I don't want to, I'd rather focus on the convention authorities, but where there is detention and evidence of, there's a dispute about whether it happened or not, a factual dispute about whether it happened, then the burden shifts and the court says, well, it's for the state to say why on earth that happened. I think that's literally the Bullitt case.
Yeah.
And of course, for that reason, but there's not a general burden shifting point about once you establish some sort of ill treatment, a burden arises that demands you investigate everything possible.
No, it was slightly more narrow than that. I think the quote is that once you've established that there has been ill treatment amounting to persecution in the past, then you have to show why. Then the expelling state needs to show why the elements that are persecutory are not going to happen again if you go. But that's a different case. Your point here is that there's a read across of the events that he concludes, the judge concludes, did not amount to persecution. There's a read across and no reason advanced and no reason to suspect that it's going to be any different, and so the judge can just be taken to have read across all those facts.
Yes. And the point about if persecution is found, then you sort of bottom out the form it takes, I suppose, or you must sort of go on to. I mean, I'm not sure quite, having found persecution, why you would need to do more effectively. You would presumably have found all those facts in order to find the persecution.
The risk of persecution in future.
But any sort of scenario.
And the problem in Democaya was that they had found some facts which included troubling stuff, and the tribunal didn't explain why the troubling stuff wasn't didn't establish, read across, didn't establish a risk of persecution.
Yes, exactly. If I could take you to paragraph 21.
But you're putting it the other way around here, which is that the past stuff didn't reveal any troubling stuff,
Yes.
and it was really for the appellant
Yes.
in those circumstances to establish what additional things there might have been that made the future risk more higher than the past risk had.
And the appellants never sought to, because the appellant's case has remained.
The past was persecutory, and therefore the future was going to be.
Yeah.
Yeah.
So there's, on both accounts, there's repetition, cross-transcription, however you want to call it.
Yeah.
Their sole issue is whether there was persecution in the first place, such that, which is why grounds 1 and 2 almost go together, really, because the facts effectively copy themselves across. And then
that isn't an end of the exercise, is it? Because the judge then has to consider not just what happened in the past going to happen again, but has to place that in the context of a risk assessment as to the future, which has as one of its ingredients what wisdom can be derived from the country information that the judge has had the advantage of looking at.
yes,
So it's not just good enough to say, I find that he's telling the truth. I find that may happen again. I find that if it did, that wouldn't amount to the definition of persecution. The judge can't stop there. The judge then has to think about, well, and also, what do I know about Vietnam and how they approach dissident behaviour or political demonstrations, and what's the level of risk for this person?
I'm not sure I agree entirely, Malone.
That's what the judge did.
Well,
If you look at paragraph 36,
at 36,
he says, I've considered whether there's a risk of repetition. Given the background material,
yes,
they might slap him or beat him again. But once they discover he's been in the UK since 2014 and only attended one demonstration in 2018, there's not a risk of them taking any further adverse interest. The background material demonstrates that the authorities target individuals who are actively opposed to the regime.
yes,
Which is why I asked you about paragraph 31. What was it about the background material that the judge said, well, I actually think what this fellow is telling me is true because it reflects what's in the country information.
But all that country information can do is support or contradict the claimed case. So if he says this is what happened to me in the past, and that chimes with the country information, the judge might say, okay, I believe you, because apparently that happens there. And then in looking at the future, you might say, well, will it happen again? What will happen to you? Well, it seems to be the case in this country that this happens. Well, that seems like it may apply to you too. So it goes to fact-finding in the past, probability in the future, but it can't enlarge the type of treatment that is claimed in the first place. If you're not saying that this happened to you, the judge isn't required to make your case for you.
Yeah, it was your submission that somehow the judge could stop. The judge needs to go on and examine what are the risks, not just on the basis of what this person described, but also setting that in the context of the wider information about the circumstances to which he'd be returned.
Yeah, that must be so, because if, for instance, the country information said since the time when he was arrested and detained and beaten up by the police in 2014 following a demonstration, Vietnam's had a real crackdown and now demonstrators are treated much more severely, that would be obviously relevant to future risk.
Yeah, there's
not just past behaviour, but also that would be relevant to future risk.
There's probably a scenario in which, say, if the individual's self-represented, where this semi-inquisitorial tribunal would say, well, you may not be putting your case as high as the government's CPIN seems to say, and in fact, I find that this new CPIN's come out and it says that someone in your position is grossly at risk. I would accept that the tribunal should look at that and might be remiss not to. But that's not the case here. The CPIN hasn't sort of added the prismatic complication for the future. Rather, it just says, I believe you. It enables the judge to say, I believe you. This is the sort of thing that will happen, could have happened to you in the past. I believe you 100%, and it's probably going to repeat, but that's not persecution.
Yeah. I mean, I'm gaining from this discussion that tribunals are not exempt from the normal requirement that they are considering a claim that is brought before them, and that I think the point that you're making is that giving unrepresented litigants all the help that is appropriate in a very serious field of this sort. Nevertheless, the court has got to consider the claim that is made to it.
Yes.
And if, for example, to take a counterfactual situation and not involving this individual, there had been unpleasant but not obviously persecutory ill treatment in the past, and the person said that there was going to be horrific ill treatment in the future for a certain reason, then it is incumbent upon them to make that point clear, because the result of that is that there could be no argument of the sort that has been had here as to whether adequate reasons were given for dealing with it. Because if such a claim was made, then any competent fact-finding, evaluating judge would deal with it and would say, well, it has been said that this is the sort of thing. And, for example, evidence was brought that my friend who went back suffered just this sort of thing, and a case was put. At that point, clearly the court has got to deal with that, particularly if it's sort of, as it were, outside what one might expect in that type of situation. But where, as I understand your submission, where that sort of point has not been made, it's not incumbent upon the court to go looking under every bush.
Yes, and to be strictly speaking, we don't need to determine that point. It's not said that there was some sort of undetermined aspect of the case, effectively. I mean,
well, I think, as I understand the appeal that's brought to us, it's that because not enough, as the appellant said, was said about the type of future risk, where, when, how, why, what, because that wasn't said, therefore it could include anything. It could include anything that you read in the report, for example. I don't mean to mischaracterise the submission, but it's a serious point to consider. But that harm of risk of maximum future harm, if it's raised, has to be dealt with. And
quite.
I didn't interrupt Ms. Dubinsky, but she said she was not claiming that her client would suffer fatal consequences from going back. I'm not at the moment understanding why not. I mean, either it's open,
yes,
and all probabilities are to be considered, or else the court defines the issues that it's considering, considers the claim that's made to it, and adjudicates upon it.
Yes, indeed. Now, if a different case was before you, or it existed at first instance, it would have been upon the judge to decide that case and to say whether there would have been worse treatment than previously experienced. But it's a different case. So that is the sort of opening point, really, that I do say is a complete answer in this sort of case. But added to it, you see from paragraph 36 anyway, that there are findings on the relevant points my learned friend said there had to be findings on. So in terms of detention, it's paragraph 36, the judge says, instead, counsel submitted that there had been the appellant had been persecuted in the past, and as the appellant is on a blacklist, he will be detained on his arrival and ill-treated again. As I've accepted the appellant was placed on a blacklist, I accept that the authorities may question him on return. Now, I accept that the judge doesn't say, and detained, but he doesn't say, and I don't find, I take exception, or I'm not with you on this thing that I've just referred to, not least when the sort of umbrella point is that he's finding that there would be repetition of the same, is the first point. So the first point is repetition, detention again, because it happened again, and that's he's finding repetition. The second point is, after immediately referring to the case put, a case which he has accepted in toto, he then doesn't say not the detention bit. And then the third point is a sort of a legal one, really, that if...
Well, you might say it's implicit in the authorities questioning him. How are they going to question him if not detaining him?
My lady, this is my point. Even if they didn't take him into custody, and I'm going to come on to the relevance of that particular point, because it's been suggested in writing, I think still, that the question of state custody is the relevant issue. But this paragraph 36 says that they may question him on return. Once they discover the appellant's been in the UK since 2014 and only attended one demonstration in 2018, not a real risk of further adverse interest. That is a description, implicitly again, if you like, if not expressly, of a period of questioning, not just having your collar felt for a couple of seconds, which in the common law itself would be sufficient restriction of movement for detention. So inevitably there's detention in what the judge says. But go on to the custody point, because my friend relied on the Article 3 authorities to say why it matters whether there's a finding of why it's material that there should have been, on her case, failure to consider whether he was detained or not. It's in the supplementary authorities. Case of apologies. It's in the main authorities. It's the case of Clifia in Italy, and it's paragraph 160 you were taken to, which is page 303. And the court there sets out, the Strasbourg court sets out some factors that it takes into account. So again, not entirely clear whether these are mandatory considerations anyway, but they are suggested as being things that are taken into account as relevant. The third is the detention one, so 160C. It doesn't say state custody, it just says detention. It says whether the victim is in a vulnerable situation, which is normally the case for persons deprived of their liberty. Brackets, and it refers to police custody. And it brings in the sort of discrete point about the conditions of detention too, which is a separate issue. But it doesn't say, so the police custody point is the factual example of Salman and Buyid. That's not per se, that location isn't the relevant factor, it's the deprivation. And the deprivation is present and found by the judge for the reasons I've just shown in 36. So it wasn't missed, there was a finding of... Then going back to the judgment and point about, it was said that the purpose of the questioning or the treatment has to be identified. Well, that's implicit, to keep using that word, in 36 also, because it says that the appellant's on a blacklist and will be detained on his arrival, i.e. because he's on a blacklist. He'll then be slapped, he may be slapped or beaten again, and once they discover he's been in the UK since 2014, only attended one demonstration in 2018, no further interest. So that's clearly the purpose and premise of the questions. So the purpose is found as fact, or assessed as future evaluation. I think a point was made too about the necessity of findings as to duration. Effectively, I think I've already said that you have the point from may question him on return, accepting the point about detention on arrival, and then its other bookend, namely once they realise that he's actually not the sort of big organiser that he claimed to be, one demo 2018, they'll release him. So that's a finding as to duration. There's no requirement to sort of put it in minutes or hours or days, and it's certainly not clear that that would make any material difference to whether it was persecution or not. Blacklist, learned friend says that it's accepted that that was considered. So even without my broad point, if you like, that in this scenario of class of case, there is this copy across issue. You have the specific findings too, in any event. Then there is my little friend's point about it's not said why it's persecution, and
Not persecution.
why it's not said it's not persecution, exactly. But my learner friend doesn't say why these findings are not a finding of why it's not persecution. And it's hard, she doesn't say what is missing. So once the take into account relevant consideration points that I've just been through are dealt with, ticked off, found to be present, those are the reasons. Their presence lead to the conclusion, or reason forth from the conclusion, however you want to put it. There's nothing more that can be added. For instance, some sort of qualitative reflection from the judge as to whether in their sort of individual wisdom they think that this is not particularly bad or not, or could be reasonably tolerated. I mean, it wouldn't add anything. In this context, the reasons, because this is ultimately a reasons challenge as was conceded, are the finding of those relevant facts that lead to the conclusion. And out with that, it's just a reasonableness challenge. Hence the descriptions of the judges being entitled to find persecution, or it being open to them on the authorities. A further point was that the judge didn't cumulatively consider all of these facts. Here we say, one, there is no proposition in law that expressly a judge must self-direct after having made these findings, set out these reasons, said, for avoidance of doubt, I find there may be repetition of those things I have found happened, that that they are being weighed cumulatively also. And secondly, where a judge in a single paragraph, 36, sets out these findings in quick succession, probably in the same sentence, they're not required to say, for the avoidance of doubt, I am not considering each individually siloed, because it's to be taken as read that they are being considered cumulatively.
I'm not sure, you may have addressed it, but I'm not sure it registered with me. Have you dealt with the question which concerned Mr. Dubinsky about the charge, the fact that he was not just arrested but also charged?
Well, my lord, I have in part dealt with it in that I said, one, that there has hitherto, even in the written argument, not been a point about this being a disregard point erroneously, fatally. Secondly, the point that its potential relevance would have been as prelude to prosecution, and there's never been a case on persecutory prosecution. And third, I would add, now that we come back to it, that what can its relevance be? So,
well, it can be relevant. I mean, it can be relevant, can't it, to the risk assessment the judge has to undertake as to risk on return. If you've got somebody who's been charged with an offence and they're going to be refouled, it's irrelevant, but strikes me it may very well be relevant.
Well, it's quite hard to see how, in persecution terms, given this whole case is not about likelihood or discriminatory reason, say, but purely about the treatment. It's hard to see how, having been charged, and it's certainly not said, so I protest to a degree in having to somehow contest this case. It's not said that having been charged will mean worse treatment. It's not said that following discovery of the charge, there will be some indefinite Article 3 type detention, or having been charged, there'll be a...
Well, if that was said, you would say, as you have already, well, the period of detention was dealt with by the judge, and we'll have to think about whether that those reasons were adequate. But I think it's difficult. I think it has to be conceded that the specific facts of the charge isn't identified directly in paragraph 36.
I mean, I'm sure you're right. Well, I'm just checking. But I mean, it's slightly unrealistic with respect to, because he's on a blacklist. The idea that he would be on a blacklist as some sort of record, and the fact of a charge not also be known, seems somewhat unrealistic, and which might be the reason why it's never been said that that was somehow an elevating, aggravating matter for its deserving its own attention.
But also a charge relates to behaviour that he has done, and the last sentence of paragraph 35, he finds that he's not going to be doing anything again. So
Exactly.
future doesn't include any charge.
Yes, exactly.
Or recharge. I mean, he's got the existing charge and he's produced no evidence, nothing to suggest that the existing charge is going to imperil him in any particular way. And there's a finding that he's not going to involve himself in any more demonstrations, so charge is not part of any future risk.
Yes, quite. I mean, unless it were said that...
He's going to be recharged for what he did in 2014, I don't know.
I don't know, or that the charge, he will be prosecuted, and somehow that there would be a discrimination point about the nature of that prosecution, be it pursuant to the charge, i.e. there's been a charging decision, a prosecution decision, and we're going to take it forward, and that...
What, arising from his behaviour in 2014?
It's historic now, but we are going to follow through on that, never mind a public interest question about the fact that we find in the interim, as the judge finds, you've scarcely been doing anything, agitator stuff. Mm-hmm. But we are nonetheless vindictively going to dig it up and prosecute you. There might then have been a case that, even if it doesn't reach a sort of severity threshold, for nonetheless was discriminatory. So my friend's example of conduct going outside of human rights, but which is sufficient from a discrimination perspective to amount to persecution. But it's just a very different case altogether. I mean, if there's one thing we're clear about, we're not in the context of discriminatory persecution or discriminatory prosecutions. It's about whether the conduct actually visited, was persecution. Sorry, I'm just going through my notes from this morning to make sure I address. Muchai, the authority that you were taken to, we say it's wholly distinguishable. It is at Supplementary Authorities, page 9. It is more like the Demikaya class of case, where there is past conduct indisputably amounting to persecution, see paragraph 4, page 10, and the question then being whether there's clear reasons for not finding that it would happen again. And Lord Justice Laws then says at 14, what does he mean when he says, I do not say there is no truth in his story and he may have been abused by the police? I.e., not clear the extent to which the account is accepted or not. Not applicable here, where there is 100% acceptance of the past facts. Paragraph 19, similarly, special adjudicator does not indicate the nature, degree or extent of persecution which he is presuming for the purposes of such a conclusion. Having failed to be clear on the extent of the past case. So yeah, it falls into a different class of case, and it's all simply factually distinct. AM, which was handed up, was a case in which there was, so paragraph 29, the lady says, second sentence, qualifications seen at paragraph 13 beg the question of what findings the judge arrived at on those aspects of AM's case. Again, it's in that other camp, not ours. In the discussion my lords, my lady had with my friend regarding the nature of future findings and whether they can, properly speaking, be analysed in terms of sufficient findings of fact when they are future, my learned friend said, appeared to conceive that it is therefore a failure of reasoning's issue. And on that, which it patently is, on that I would bring in, remind the court of, probably doesn't need reminding, but it's particularly important, I think, in this case, given the nature of the challenge, the principles summarised at paragraph 72 of H.A. Iraq, Lord Hamblin, which is Supplementary Authorities, page 68. So 72.1. And Lord, my lady may want to, if you could just read 72. This, I mean, you may know this. I expect you will know this.
Sorry, what page of the supplementary one was
68
it?
authorities.
68.
But if I could just highlight this, because I suspect this is well known. So, in relation to A.H. Sudan, appellate courts should not rush to find misdirection simply because they might have reached a different conclusion on the fact or expressed themselves differently.
Paragraph number?
72.1.
Thank you.
And then 72.2, where a relevant point is not expressly mentioned by the tribunal, court should be slow to infer that it's not been taken into account. And then 3 expressly deals with reasons. When it comes to reasons given by the tribunal, the court should exercise judicial restraint, not assume the tribunal misdirected itself, because not every step in its reasoning is fully set out. And I would suggest that this appeal has lost sight of that to an extent. And to my learned friend's reliance on the anxious scrutiny principle, which was summarised in MN Somalia as involve a need for the decision to show by their reasoning that every factor which might tell in favour of an applicant has been properly taken into account. That's paragraph 31 of MN Somalia, page 39. That doesn't disrupt, if you like, the principles summarised by Lord Hamblin in H.A. Iraq, because the first 2 cases on that list are asylum cases. Both A.H. Sudan, Darfur case, and M.A. Somalia, both asylum cases. So if there was some sort of exception for cases where there was a anxious scrutiny applied, then it would have been stated, I would venture. I think that's all I have to say on the first round. The second and third will not take quite as long. The second, and effectively the second, has been addressed by points I've said already. So this is the past findings being erroneous point. The simple answer, as I've said, being that he accepted all the findings.
I think the point that's being made is that they were then sort of, the findings were then reduced into one aspect of them, and that the whole weight of them was not properly brought into account.
Well, I think that's the cumulative point again. Then, my lord, that
Yes, I'm not inviting you to
yes,
repeat any
I just-
submission,
yes,
but I mean,
yes.
that's what I understood. The
Yes,
second,
well-
second point to be that it was unduly simplifying
yes,
the court's findings to refer only to
yes.
physical
Well,
assault.
just on that, my lord, much as I've made the point about cumulative, it becomes quite a slender appeal ground to say, okay, you didn't err in sort of not being with me on a given issue, but rather you didn't, despite accepting it all, you didn't sort of add them all up together. And then the second point is, because as I say, there's no sort of requirement to expressly say so, and inevitably the evaluative exercise does add it all together. But also, there is legitimacy and logic in focusing on the beating as the, if you like, index act to which these surrounding issues, its location, its duration, its purpose, colour that act. They are its context. And as context, they are inherently considered in the finding as to the individual event. It's not like a separate, you failed to take into account that 2 years earlier I was also done over on a separate occasion. So that sort of detachment, attempt to detach and say you failed to take them into account is unsustainable, I submit, as a reasons challenge or on any basis.
Certainly that seems to be the way that the representatives at the time seem to have considered it, because look at the way that it was taken forward to the appeal. It was beatings and blacklist. That was round
Yes.
3, was all about beatings and blacklist.
Yes.
And the rest was implicit,
Yes, quite.
to coin a
quite.
phrase.
So there is the point about the scope of what's actually been raised
Yeah.
in front of the poor judge, who can only deal with what's in front of them. A point was made on this second ground about the reference to Kaya being insufficient. I mean, Kaya was referred to in the context of the findings as to future happenings and risk. So I'm not sure why it comes up at this stage, but as to it being insufficient, I infer insufficient for Stanley Burton, Lord Justice, 3-stage test of fact-finding, identify the threshold. That's incorrect, because if we look at Kaya, it contains discussion of Demi-Kaya, which my own friend describes as the seminal case. It contains reference to Professor Hathaway's definition. So paragraph 13, page 81 of the authorities. So it was a very good point from which to identify the relevant threshold. Apologies, I may have again be looking at a different case than which I thought. Yes, that is. Oh, apologies.
Kaya is at page 24.
Yes. Yes, sorry, the reference to Demi-Kaya in Kaya is at paragraph 6. Seven, 8 to 9. So it was sufficient reference.
But the FT. Oh yes, I see. Yeah. Yeah.
Just whilst we're on Kaya, which will lend Judy, hopefully gets me back on the rails as to where it actually is. Paragraph 7 contains reference to systematic conduct, which is of course relevant to ground 3, and that apparently it is a phrase used by the Federal Court of Australia in Ibrahim.
Well, there's actually a footnote about that in Professor Hathaway's latest book, going into.
Right. I mean, would the lady like me to look at that? Or?
No, not particularly. I mean, I've already looked at it.
Okay.
I've seen what was said about Ibrahim and systematic.
Okay, thank you. Then turning on to then the third submission. It was the point here, the narrow point was that the statement in paragraph 36 as to persistent or systematic was erroneous as to the threshold. And then it was clarified that persistent's fine. So it's just about whether systematic is not. And I think there's a number of points to say on this. I'm trying to be helpful on this. First is that looking at the judgment at 36, it's that question at the end of the paragraph is concerned with is not all that's said about where the relevant threshold is. There is also the statement with reference to Kaya regarding sufficiently serious. So almost whatever systematic or systemic means, and I can take you to criticism from Lord Justice Laws about Professor Hathaway's use of that term, whether it's sufficient to capture seriousness. There is this agreed principle that there is effectively a spectrum, if you like, of one-off sufficiently serious acts, a la Kaya, a la that statement in the middle of paragraph 36, and then on the other end, less serious acts, but which are nonetheless persistent or systematic. So, so far as Malone Friend says that, seeks to say, because certainly I would say the term systematic can't be erroneous where it's used by Simon Brown Lord Justice Simon Brown in Ravichandran as set out in Dharmakaya at paragraph 15, which is page 18 of the authorities bundle, or in the OED dictionary definition of persecution that Lord Bingham, in Sepet refers to as set out in MI at 56, page 171. So even quite apart from, so the term is fine, but so far as the point is that doesn't cover it, because persecution can also concerns potentially individual one-off acts, and it's not just about repetition or something that has systemic, endemic qualities. We agree, and the judge agrees, and referred to it in the middle of this paragraph. So the materiality point, which is where Malone Friend got into Article 3, doesn't arise if you're with me on that there's no error in the first place. And I'd invite you to so find and not to get into materiality, because not only because we don't get to that point, but because we're not saying it's immaterial. So it's not sort of put in issue. We haven't at any stage said that these issues, as found by the judge, were immaterial. We say he did consider them. So it's not quite clear why this point arises as to materiality. But also I would discourage the court from getting into this issue in a case where it doesn't strictly arise, because it's not entirely clear that there is this as to what the answer is ultimately, and it's not For instance, put it this way, my learned friend adopts and relies on Demikaya, a case which says that a one-off beating isn't per se persecution.
So not invariably.
Not invariably, yes. I mean, I'm not sure what the difference is, but I'm happy with invariably. And then in JD and Sweden, in your supplementary authorities, Strasbourg case, the court at paragraph 79,
Page
148, my lord, sets out the general principles concerning the application of Article 3 in expulsion cases. And we added this to the bundle because the two cases that my learned friend relies on in relation to this materiality issue are not expulsion cases. Bouillet is detention in Belgium by the police, and Kleifeld is reception conditions in Italy, I believe. This is an expulsion case, and in this long section beginning at 79, the court discusses the application of Article 3 in expulsion cases, and they say so, for instance, so the headline point, which I'll then take you through what illustrates it, is that they cleave very close to the refugee convention context, the asylum context. They do not say there is a distinct threshold. Yet that would be very much a significant concern for the Strasbourg court when applying Article 3, when considering cases that are effectively almost appealing from domestic asylum proceedings, to say, a main concern for us is that we apply a different, nay, lower threshold. Rather, what they say is matters very similar, if not the same, to convention cases. So 84 FG in Sweden, the court described the nature of its examination of cases concerning expulsion of asylum seekers. Its main concern is whether effective guarantees exist that protect the applicant against arbitrary refoulement. And towards the bottom of page 150, the court must be satisfied that the assessment made by the authorities is adequate and sufficiently supported by domestic materials. Assessment of the existence of a real risk, so similar questions as to likelihood and the standard of probability. A burden of proof point begins at 91 onwards, and reference it, and it says that the court says at 93, owing to the special situation in which asylum seekers often find themselves, benefit of the doubt. 94 more on that same issue. Paragraph 98 refers to guidance note from the UNHCR. At 99, we see that sort of cardinal protection claims principle that we speaking about, namely past ill treatment as indication of risk. 100 UNHCR and the qualification directive, no less. So I could go on, but the point is they are very much expressing that they follow a similar, if not the same, approach to in expulsion real risk cases. And there's no mention of a different threshold. So if Demikaya is correct, as Milena Friend says, it's a seminal case, and it's not an aberration, it followed Ravichandran, then on the evidence of JK, or on the authority of JK, then that also is the case for Article 3.
What's the case?
That, as per Demikaya at 19, it's a one-off beating is not invariably persecution or Article 3 ill treatment. Apologies, I'm just checking with you may have a further point. No, nothing further unless there's anything from the bench.
Let me see if I've got this right. When we're thinking about risk in the future and basing it upon findings about past harm, it seems to me there might be at least two main possible situations. One is one where it was established that there had been past persecution. That was that the degree of and nature of the harm was such as to qualify as being persecutory. Now, in that situation, would it be right to say that at that point, in a sense, it's for the state to show that that's not going to go on again in like circumstances if there was a return into that
Yes.
area?
I think that's, yes.
That might be, I mean, I'm not suggesting that in deciding whether somebody's being persecuted, you break things down into separate compartments, but you have to have a process of analysis.
Yes.
Contrast that with a situation where it was found that something bad had happened, but it was not persecutory. In that situation, the court is bound to consider whether there was going to be a repetition of something that might either be so much worse that it would be clearly persecutory, or that a course of conduct, as it were, adding the various elements of the experience, meant that something, two things, five things, as it were, that individually were not persecutory, as a group of likely experiences were. But if you start from the position that what's happened in the past is not persecutory, that doesn't of itself shift a burden onto the state to show that it's going to be not going to be persecutory in future. Is that how it works?
Yes, and I would submit, my lord, that actually the burden shifting point doesn't add anything, quite apart from whether it's legally correct, because in the scenario in which there is past persecution, and it's fairly clear, see various cases that we've looked at of that, the appellant, the applicant in the first instance, is going to be saying, look what I've experienced, I'm at risk.
Yep.
So there's no sort of burden shifting type point. It's literally their positive case to which the decision maker has to accept or not accept. I mean, quite strange. I mean, I go back to the litigant in person scenario. There, maybe possible to envisage scenarios where I mean, even then, I'm not quite sure.
Well, I've been persecuted in the past, but it's changed. It's all changed over there. Things are much better.
If they're saying it's much better, I'm not sure why they'd have a claim.
No, but you're saying
right.
It's much better. I mean,
I see. If the Secretary of State was
the Secretary of State was saying, well, there's been regime change.
I think they say that all the time.
They're now in the presidential palace.
Yes.
It's different.
Yes, you get questions of, is the test for departing from country guidance sufficient because there's been durable...
But at that point, the ball would be in your court to show that something that had been persecutory in the past was no longer something to be protected.
Absolutely. That's the Dimakaya case. Failure to make those findings. Yeah.
And in some cases, there'll be a mixture of the two, won't there? There'll be a, can we believe everything that that's being put forward?
Yes, which was
and you do
your
need
case,
then,
AM.
And then you do need reasons for what the basic findings are that you're carrying forward.
Being very clear
to establish a risk in the future.
I accept this, but not that.
Yeah.
And given I accept this, that may recur. That I find didn't happen. So because there's all that sort of sui generis issue about credibility in the asylum context, and the fact that someone's not to be believed on that doesn't mean, given the objective evidence, it might still happen to them. Yeah. It's a very involved area, but I do say that.
And with a low standard of proof.
And with a low standard
of
proof.
In this case,
exactly.
The new NABA provisions were not in place in relation to this appellant, because he claimed asylum such a while ago. But
Yes.
yeah, even so,
Quite. But,
the risk assessment is at the lower standard,
that's
even under
yes,
the new
that's
legislation.
sacrosanct. That reasonable degree of likelihood standard. But in the scenario where it's all accepted, and there's also acceptance of recurrence, you're not in the risk territory. It's not a case about risk then. It's simply whether all these agreed accepted facts meet the threshold. That's this category. And in that category, you have these different this class of case, namely about, I won't repeat my submissions, but I hope it's helpful to look at it in terms of those classes. The one that's repetition of low level versus the obvious persecution and the necessary findings, therefore, as to recurrence or not. Because there's an obvious absence and omission by a tribunal decision maker. But where there's acceptance, both of the past events and of the repetition, it's very hard, I would say, to bring a reasons challenge, because the reasons are implicit, transcribed across, populated by the acceptance of the case put by the individual themselves.
And as I understand, just to sweep up your argument under ground 3, you were saying earlier that if you succeed under arguments 1 and 2, what you would have established was that there was a lawful fact-finding exercise, both as to the past and as to what may happen, whether that's a fact, strictly speaking, or a mixture of fact and assessment.
Yes.
But then under argument 3, having done that lawfully, I think the point Mr. Dubinsky makes is, well, you've still got to make sure that you've self-directed correctly in relation to persecution, which is where her distinction about systemic and systematic comes in.
Yes, absolutely.
Yeah.
No, quite, my lord. And really, the best answer to that is the reference to Kaya right in the middle of the relevant.
I was going to say, then your answer to that is yes, but systematic is a word that has been used in this court in cases where whether it's persecution or not.
Yes, and really query the utility of it as a term beyond what it adds to repetition and persistence. Because if systematic merely means, per my lord's suggestion, that state administered rather than third party, it would almost mean that whenever the state's doing it, you've got persecution, which can't be correct. Hence, Justice Law's querying whether Hathaway's statement is gospel. You've got. I could go back to the point which is encapsulated now in, I think originally in the Qualification Directive, now in Section 31 of the 2022 Act, about sufficiently serious alone, not particularly serious, yet extremely repetitive. That's the best way to look at it, I would venture. And we were in the former case here, because it was said that a bit of questioning, sadly this repetition, and then no more. So it's one-off, hence Kaya, Demikaya, paragraph 19. So we're in that scenario here.
Thank you.
Yes. Thank you, Mr. Tabori. Yes, Mr. Dubinsky.
My Lords, I apologise, there will be one further authority, although I think it's one that will be very familiar to members of the court and also to the respondent. We are bringing hard copies, but they haven't arrived yet. Could you email everybody? It's Karen Akaran.
Well, look as if there may be. I think the cavalry may have arrived.
It may, yes. But I won't turn to that immediately, and of course,
Have you pronounced that correctly?
possibly not.
I always thought it was Hoan and Hoan.
My Lord, I will take it from the expert.
Well,
Karen Akaran.
I'm not the expert, but I recall that was the presentation we had at some training, not long after it came out. I think from Upper Tribunal Judge War.
My Lord, I wouldn't dare to dispute that. But I'm not going to Karen Akaran first. I'm actually going to start at the end, as it were, which is argument 3, and take the invitation up of Lord Justice Jackson, which is to start with the proposition of law, which was proposition 5 of the various propositions you heard at the start. What is the test for persecution? And our simple point, and we say it has been rather illustrated by the discussion that has just been, is we don't know what the first tier judge meant by systematic. If he meant repetitive, which does seem a logical inference, then that was wrong. There is no requirement that treatment be repeated. If he meant coordinated, that was wrong. And as I said earlier, if he meant intentional, that was right, but how could a beating be non-intentional? So he can't have meant that. Now, I take it that if I understood right, Mr. Tabori does say, well, he must have meant basically systemic, which is inherent in the system. But if that's what he meant, then it was incumbent on him to explain why, given the background evidence and given what had happened to the appellant, and given what he accepted was going to happen on his rather minimal explanations of what would happen in the future, why is that not inherent in the system? Why is that not systemic? So we say systematic is indeed a term that does feature, and my lady pointed out that Professor Hathaway has said with some frustration that the Australian jurisprudence has taken a wrong turn and by using the term systematic, when the problem is that systematic can mean many things. Won't take you to it, but Australian judges have actually deprecated the looseness of a term and tried to define it. But the relevant reference is Professor Hathaway, page 388 of the main authorities. I'm not asking to turn it up. Footnote 78 to 79, where the eminent academic says essentially this is leading people astray, and we say that's what's happened here. Now, Mr. Tabori's other answer really now on systematic and the vagaries or vagueness of what that might mean says, well, in any event, the first tier judge says not sufficiently serious. But again, that begs the question, why? Bouygues is a case where a one-off beating to the face in police custody was degrading treatment. If what's accepted here, and it's not clear, is that this is a beating in the custody of the state to the face, why is that not persecutory? Some readings, some reasoning is required here. And
well, sorry, but is that not an evaluative assessment that the judge is called upon to make? Why does he need to say more than that, in my view, this wasn't sufficiently serious? This behaviour was not sufficiently serious.
My lady, I'm going to come back in a moment to the issue about detention, but it does come down to what kind of a beating does one have in mind here? So the background evidence.
He has in mind the beating that there was before, which has been told about
and I'm
by your client.
And I'm going to come to that in a moment. First of all, we say it's not clear, and it's certainly not the case that this was a situation where what was being said is you read across, identical treatment will recur. That's not that's not the submission. That's not the case. One looks at paragraph 7, Roman numeral 1. That's not the submission that's before the first tier tribunal, not the issue that's before him. And nor would it be logically. And I'll come on to that in a moment. But the other issue, and to which I will also turn, is that we say, why was the past treatment not sufficiently serious? And there is a problem, which is that, in a sense, what the respondent's submissions do is assume that much must be demonstrated. So they're essentially saying, well, the past treatment wasn't sufficiently serious, wasn't persecutory, and therefore the judge was entitled to infer that the future would not be. And there are several problematic assumptions in that. One is that the very finding or the very conclusion, evaluative conclusion as to whether there had been serious harm or persecution in the past is under challenge here, and I shall come back to that. But the other is that there is not a simple read across, and that is what I want to come on to now. So Mr. Tabori says past harm populates future risk. And we say that's not so in this case, and nor is it the case in general. And that's, I'll take the in general point first. Of course, as we all know, there is no rule that there must be past persecution to establish future risk, nor is there any rule that future risk will be of the same nature as past harm. The risks in the future may be higher or lower. And that's no doubt why Article 4.4 doesn't say you assume the same treatment, but it also doesn't say only past serious harm or past persecution are indicative. It also says the direct threat of this. And we do say this is a case where the blacklisting, yes, the criminal charge, the warning of, and I quote, further detention and arrest in the near future, those are direct threats of persecution. So another way, so it's not the case that one simply reads across from what happened in the past, what happened to what would happen in the future. Not clear that that's what the first tier tribunal did, I should say, in fairness to him. But if that is what he did, it wouldn't be adequate.
I don't think this was being put as if it was a legal rule. I think it's part of a discussion as to the framing of the issues that arose in the individual case.
And, my lord, if one looks at the framing of the issues, at paragraph 7.1, the issue before the judges has the appellant established to the lower standard of proof that he would be at risk of returning to Vietnam because of his imputed political opinion, not is he at risk of a complete mapped repetition of what he has had before.
But lying behind that bald statement of issues was then a consideration of the case that was put. I mean, the appellant was the only person who was capable of putting a circumstantial account of what had happened. Everybody else was tasked with assessing his account and accepting it as it turned out. The court had to work within the framework of what it was being given. Firstly from the appellant himself, then from other sources of information, CPIN, report and so forth. But I mean, you must surely accept that you know, a judge approaching this and seeing what is on his or her desk will say, right, I see, we're in this territory. It's not that I have to do the whole of the convention and every possibility. We are in this territory. These are the issues.
My lord, yes, but that is a broad issue, and it is the sort of issue that the tribunal is expert and used to dealing with.
But it has to listen. I mean, it listened to your client giving evidence and being questioned and so forth, and read a lot about it, and will have formed a view as to what sort of persecution was being proposed here.
My lord, the appellant is obviously the key source of information, and often will be the only source of information, not invariably, as to what happened in the past. About what happens in the future, of course, the first tier tribunal will look at an array of information, and in this case he has before him the country evidence. Can I just come back to just a simple logical point, if I can put it this way? The problem with mapping past persecution onto future persecution, before one even gets to the problem that I'm dealing with, which is that actually we say there's an error in terms of appreciating the gravity of what took place in the past. But leaving that for later, if the appellant hadn't left, then the evidence appears to be, his evidence, which is accepted, is that he's threatened with being arrested and detained. So, and we don't know how for long. So how long? The point being, this is not a case where it's being said exactly the same will happen before as has happened. Sorry, I beg your pardon. Exactly the same will happen in future as has happened in the past. So if we look at
But he was arrested and detained for involving himself in a demonstration.
yes,
And the judge finds, as a matter of fact, that he's not going to involve himself in demonstrations again. So the opportunity for detention and charge with involving himself in demonstrations is not going to reoccur on the judge's findings.
my lord, my lady, I beg your pardon.
So what you're looking at is what will be carried over from his past behaviour. What consequences may still exist by reason of his behaviour in 2014.
Yes, quite.
No fresh.
And well, there is
occasion.
there is a finding here, an indication that it is not considered that he's going to go out and demonstrate in future. And we're obviously not going behind that.
No.
So I absolutely accept it is about what risks arise from the past circumstances.
Yes.
That I accept. I'm simply saying the past does not map directly onto the future, because one has to ask the question, what would have happened to him had he not gone away?
No, but if this is a normal... I mean, I think we're rather overcomplicating this. This is a normal process of human reasoning, that what is the risk? I look at what the risk has been that I've found in the past, and I think, is that sort of risk going to happen in future? Of course, there may be circumstances where it'll be a different sort of risk, maybe a worse sort of risk. But in general, when you're thinking about what conclusions can you draw from the past and the account that's been given, you will tend to think in terms of the same type of risk. It's not an iron rule, but it's a normal process of reasoning.
Of course, my lord.
I think what might be helpful, we don't have it, but this is why I asked Mr. Taboria about it earlier, is the relevant excerpt from the handbook, which talks about the relevance of past persecution, because that we've got umpteen cases that deal with that point, but it is from recollection, and I hesitate A, to try to recall it, and B, to think aloud, but from recollection, it takes it essentially as a starting point, not an end point. We've got, with the extract we've got, isn't actually the pertinent one.
I was just checking
I
whether
knew
we had
you were,
it. Yes.
I'd already checked it, and we don't have it, and so our dependable research resource, Miss Irving, may be commissioned again to find the right bit. But it talks about, doesn't it, effectively, how somebody has been treated in their home country in the past is evidence of the potential for them to be mistreated in the future. And that's what all of these cases are redolent of. It is the starting point. That, in this case, what we also have, though, is the end point, which is what the judge made of it. And then you have your points about whether he came to his findings correctly or not.
And I won't labour the point, but I just to make sure that I'm clear, and I apologise if I haven't been clear, I am talking about the Article 4.4 of a qualification directive point that I took you to in JK in Sweden, that says that the direct threat, and I'm sorry, I'm paraphrasing now, but essentially of treatment that would constitute persecution or serious harm is a serious indication that this will happen in future. And the point I'm making is that what happened in the past was beating, detention, arrest, fingerprinting, but also the threat of prosecution. What is a criminal charge? It is telling someone we're going to prosecute you. Yes. And what is telling someone you will be arrested and detained?
This is a challenge to the primary finding that what had happened in the past is not persecutory. You're challenging that.
That's a separate issue. I'm actually saying
but you're further saying that even if you're wrong about that, then you're still left with what has to be evaluated for the future.
Yes.
Because you can amalgamate non-persecutory individual events to make a persecution.
Yes, but also because a person could have been threatened and they could have which is one reading of what's happened here, they could have jumped bail and be facing prosecution on return. That would be an example of someone who faces a threat. It hasn't materialised before their departure. It would materialise upon return. But I am not going to go further at that point. But so my point was simply to say whether in general or in this case, it is an excessive simplification, despite the rather poetic terms, to say that one maps the past directly onto the future. It is a serious indication of what will happen in the future. That is all. Now, still with future risk, so I'm now on future risk. We say that detention, the question of whether a person will be detained while beaten, is a key component of future risk. So when somebody is asking a question at paragraph 7.1 of the FTT determination, of whether there's a real risk of future persecution, it is an essential component of that, if detention is an issue, to determine whether it will take place. And we say either the prospect of future detention is not accepted. If not accepted, why not? Or, and this is, I think, Mr. Tabori's point, it is accepted. If so, why is detention and beating not persecutory? And so again, Mr. Tabori's, and I apologise if I'm misparaphrasing, but essentially his answer is, well, because it's not persecutory, because it's not sufficiently serious. He said what he had to say, but again, that assumes the correctness of that which must be established, that which is under challenge. So, and then the third option about detention, which is actually what we think really happens, is that it's left hanging. It's simply not addressed. And we do say, and this is where Karen comes in, and I sincerely apologise for burdening the court with yet another judgment. I think we're going to hand it up.
Got it.
So this is... Thank you very much. Okay. And I apologise because I am going to the judgment of Lord Justice Sedley. Sorry, the version I looked at didn't have paragraph numbers, so I'm trying to... Yeah, it's... I'm sorry, let me just find it. 479, page 479, so this is the penultimate page of the judgment. This is Lord Justice Sedley's judgment. And could I ask you to read from, like Lord Justice Brooke, down to the end of that paragraph.
Yes, thank you. Okay, shall we do that?
Yes, thank you.
Yes.
So the point I seek to make here, and I apologise that it may be obvious to use a common term in this jurisdiction, is that actually that there is not a fundamental distinction between the assessment of past and future events. In both instances, because of the difficulty in this particular field, where matters will not be evidenced, in most cases, even as to past events, what the decision maker is engaging in is an exercise of evaluating matters that happened in the round and matters that will happen in the round. And then just to cite from partway through this paragraph, no probabilistic cutoff operates here. Everything capable of having a bearing has to be given the weight great or little due to it. what decision makers ultimately make of the material is a matter for their own conscientious judgment, so long as the procedure by which they approach and entertain it is lawful and fair, and provided their decision logically addresses the convention issues. And the convention issues, from first to last, are evaluative, not factual. So, in other words, both as to whether something happened in the past and as to whether something will happen in the future, there is an approach of looking at the evidence in the round and looking at whether there is a reasonable degree of likelihood that the asserted event took place or will take place. And Mr. Tabori, as I understand it, says, well, you don't need to look at the background material to look at what will take place, because you've just got to look at what the appellant says will take place. And that's just plainly wrong. And if we're needed authority, one hardly does. We have it here.
I don't think I understood him to be saying that. I understood him to be saying that you take into account, the judge will take into account what's happened in the past, and also there is evidence in the form of country reports, which he will also take into account. So it's obvious,
I apologise if I misunderstood. I understood Lord Justice Dove as saying you don't just look at what the appellant says. You don't stop there. You look at the country background material.
Course, yeah.
And Mr. Tabori, if I understood correctly, said, no, I don't agree. And he said you have to look at what the appellant says will happen. So he...
But I understood that in terms of setting the parameters of what the judge will be looking at. If the appellant doesn't say, I'm going to be detained for months and months awaiting prosecution, you don't look at the country reports for evidence that he will be, because it's not his case that he will be.
My lady, I would, with great respect, not agree with that. So in this particular jurisdiction, because of the anxious scrutiny requirement, a few particular features arise. One is, of course, appellants are not best placed to assess future risk. And so this is why, in this particular context, it is so critical, and almost invariably does occur, that decision makers will look at country background material, which may not even have been adduced by the appellant, represented or not. And of course, if there is what is termed, and I apologise for referring to a judgment that's not in the authorities, but I think the court will know it, it's Robinson obvious. So where matter, either as a matter of common sense or often as a matter of international law, arises, even if it has not been raised by the appellant, then the decision makers, and that includes the tribunals, will need to have regard to it. So we do say it's very different, and if one needed authority for that, that's clear from paragraph on page 479, for example, of Karana Karan.
But they're relying on the appellant to identify what that other material is and put it before them. Unless, as we've just seen referred to, they have some personal knowledge, in which case they'll apply it and identify it through their experience of sitting on these sorts of cases. But you're reliant, apart from that, you're reliant on the appellant to put the relevant material before you, aren't you, and to make the arguments based on it.
My lady, actually, this is very unlike an ordinary civil jurisdiction in which it's adversarial, and in a sense each party puts their case and fights to the bitter end. So it's actually supposed to be a joint fact-finding duty by the Home Office and the individual appellant before the tribunals, and in which the judge is also engaged. So it is very different. One is not... Clearly, there is a need for procedural rigour, as my Lord Justice Dove has pointed out in cases such as Lauter and TC, and this is certainly not a suggestion, but there should be a free-for-all. But I am also saying that one does not carry over the strictures of ordinary civil litigation to this area in which many
Well, it's
will
a polycentric form of decision-making.
Yeah.
And it may be, for instance, one has experience of cases where an appellant has been found wholly lacking in credibility. But because of some particular feature of his case. For instance, he can't produce the necessary document which he needs to produce in order to gain access to his home area, or there is some other a change in country circumstances which mean that his particular ethnicity may be at risk, which would mean that although he's completely failed to establish any evidential basis for his subjective case, nevertheless he may bring himself within the scope of the convention.
Yes, my lord. And of course, that won't necessarily rely upon the reports that he himself produces. So it is very common in this jurisdiction for judges to take points of their own motion and to tell the parties, I want you to address this, whether or not parties are represented, because of the anxious scrutiny element here. And to follow from that, for example, to follow on from my Lord Justice Dove's point, my Lord Justice Daxon said, well, yes, of course, there could be a situation where an individual says, well, I wasn't badly treated, but my friend was really badly treated, so I had a lucky escape, but look at what happened to him. But the equivalent of that, on a broader and more authoritative basis, is that the judge must look at the country background evidence. It's not looking at what happened to one friend, it's what happened to a whole class of people. I won't take you to it again, but I showed you the report. And my lord said, well, no, I think actually it was Mr. Tabori's word, you don't go looking under every bush for a point.
No, I've said that.
I'm sorry. But this isn't looking under a bush. There are two reports cited by the first tier tribunal. This was a detailed report.
No, but the point that I was making was that if it had been your client's case that he was going to be subject to prejudice on a completely different order of magnitude, then that was something that could have been put to the court, and the court would then have had to deal with it. I mean, otherwise, one assumes at this level of court that the decision maker dealt with the case that was before him, and likewise that the first appeal court deals with the appeal that was before them. And so if a different case wasn't put to the decision maker, then that would mean that there had been, that the issues had not been correctly defined.
My lord, you've already heard me on the point that the issue was sufficiently broad that it certainly comprehended that, but I won't labour a point that I've already made. I'll come back instead, if I may, to the question of detention. So still on the question of future risk, the question of whether the appellant will be detained, we say it is unclear what was held. Mr. Tabori says, well, we must infer that he would be detained. But it is the case, could I come back to a point that was put to me by Lord Justice Jackson, but in this jurisdiction, yes, one does assess, will the person be detained, and if so, for how long? And in a sense, if one needed authority for that, it's Karen, which I'm afraid I'm again mispronouncing, but it is, one does look in the round at what are the events that are going to take place. So if you don't accept my point, which is that this is not like standard civil litigation where one looks rigidly at a set of, are these in the particulars of claim? This is not in your case. But we say that's not the approach that applies here, has never been, that it would be extremely unorthodox to suggest that that does apply here. There is procedural rigour, but not of that form. But putting that to one side, detention was squarely raised, and the question remains, how long, what conditions, will he be detained at all? Why is detention plus beating not either cumulative circumstances which taken together, this is Regulation 5.1b of the 2006 regulations, constitute persecution, or to put it another way, and this is why I took you to Bouillid, a beating that is rendered more degrading by the humiliating circumstance that the individual being beaten is being beaten to their face by agents of the state in detention. And So we say the elementary reasoning is missing. And could I just on that note ask you to turn please for a moment back to Bouygues at page 10. This is page. I beg your pardon. I think I've got the wrong pagination here. Sorry, it's page 236 to 237
Of the core or
main authorities. I beg your pardon. And could I ask you to look at paragraphs 106 to 107? So the proposition that was rejected in Demekaya was any beating in any context, or that's certainly how it reads, will be persecutory. And the court says no. One has to look at the facts. And in Bouygues, we see that facts such as, actually, I'm just going to also draw your attention again, 104, beating to the face, but then beating administered by law enforcement officers, and then most importantly, 107 for our purposes. This is why we say it really matters what is being anticipated here. And my Lord Justice Jackson was surprised that it is absolutely standard in this jurisdiction, and Karen is the best authority I can show you for that, for there to be assessments along the line of where will the person be detained if he's detained, and by whom, and for how long. This is part of the assessment that in which judges are required to engage to discharge their functions when assessing whether there is a future risk of persecution. So we say it is greatly problematic that the question of detention has to be inferred here. There's simply no clarity on this. Now, turning to the past now, that also raises the question, having just showed you Bouygues, of why was the past treatment not persecutory? And it is a reasons challenge.
Is this a response?
Yes. Yes.
I mean, in a sense, I get the feeling we're sort of circulating around the same issues. Again, we've got the points on those matters. So if it's in particularly picking up on something that has not so far been dealt with, by all means.
Yes, I'm just looking for where. Sorry, I'm just looking for where I am now. So, Mr. Tabori's point is that you can take it as read that the past events were looked at cumulatively, but we say one has to look at what is actually said at paragraph 36 of the determination, which is to look at the single beating. And if he was looking at the events cumulatively, then it certainly was incumbent on him to explain, because prima facie, these events taken together amount to persecution. I'm sorry, I'm just checking. So, and just in response to another point made by Mr. Tabori, and your Lordship and my lady will be pleased to hear that I'm coming to an end. Mr. Tabori says one can't say that the past findings are erroneous. He accepted that the first tier tribunal judge accepted what was said, but the point is, of course, he doesn't give reasons as to why this concatenation of serious events and threats threats, we will prosecute you, we will arrest and detain you. Why does this taken together not amount to persecution? And for all the reasons you've heard about the serious indication of that past persecution leads to, or future risk, that meant that the tribunal was operating at the wrong starting point. And finally, Mr. Tabori says, well, there is legitimacy and logic for the first tier tribunal in focusing on the single past beating and the single future beating. And he says the surrounding issues colour that act, they are its context. But again, why are these matters not persecutory? And so we do say, ultimately, the various parts of this challenge come down to the point that this is an unsafely reasoned judgment, and that it is unsafe in this anxious context in which safety and liberty are an issue to infer reasons that are absent, or to try and piece together from different bits of a determination what was really meant, and especially to infer, which Mr. Tabori's case requires you to do, a finding that someone would be detained, but that somehow that detention plus the persecution would not, sorry, that detention plus the beating would not be persecutory. Unless I can assist further, that is my reply.
Well,
I'm
thank
sorry,
you.
my lord.
Thank you very much.
You would mind, my lord. Sorry.
You want to say
Just
something about
regarding
this?
Karen Ackeran, just a couple of points, my lord. Sorry. The first is a short point, just regarding Lord Justice Sedley's judgment, also 479E. I would say supports our case on what I said about how in the evaluative context, after the findings, after the thresholds identified, that those considerations, once it's been identified that what's been taken into account, and you've got past the failure to take into account relevant considerations issue, are the reasons, stand as the reasons. See His Lordship's statement at E. The facts, so far as they can be established, are signposts on the road to a conclusion on the issues. Seems to support what I was trying to say. And then the rest, the only other point is just regarding a few points within the two judgments which do seem to say that it's whilst the knowledge of the judge or the relevant CPIN that seems to relevant to the issues raised might be taken into account by the specialist tribunal, it is relevant what is actually contended. See, first I saw was paragraph page 469J. Similarly, if an applicant contends that relevant matters did not happen, so just the point of the relevance of the actual case put, and then 470B, the end of I think the same paragraph, unless it considers that there is no serious possibility that the facts are as the asylum seeker contends. And then 472C to D, the fact finder must be careful, however, to evaluate each of the considerations suggested on behalf of the applicant. In my judgment, it was completely wrong for the tribunal in the present case to dismiss considerations put forward by experts. So I do say that whilst to take into account the sort of special nature of this, the protection jurisdiction, it's not completely irrelevant what case is actually put.
Thank you very much. We thank you all for your arguments. We'll take time to consider our decision and let you have it in the form of judgments that will be handed down in draft in the normal way for your help with any editorial corrections and the creation of a draft order. If there's anything about the draft order you can't agree, short written submissions will suffice, and we'll decide those without the need to trouble you for further attendance. Please make sure that the embargo at the top of the draft judgment is strictly observed. Thank you again.
Thank you.